SJC-13270, Commonwealth v. Christopher Rambert.
Okay, Attorney Coase.
Thank you. Good morning, Your Honors. May it please the Court, Matthew Coase here on behalf of the defendant, Christopher Rambert. The foundation of this Court's holding in Perez is that there is an unacceptable likelihood that the brutality of a particular offense or offenses would overpower the mitigating qualities of youth during sentencing. This happened to Mr. Rambert twice, both times he was sentenced. At his resentencing hearing in 2021, the Commonwealth waived the Miller hearing and declared that it would not attempt to demonstrate extraordinary circumstances necessary to seek additional punishment. And secondly, during Mr. Rambert's resentencing hearing, the sentencing judge mistakenly believed that he could impose a sentence that was presumptively disproportionate. The end result is that Mr. Rambert's presumptively disproportionate sentence was replaced by another presumptively disproportionate sentence. The new sentence violates Article 26 for two distinct reasons. The first reason is it does not allow for parole eligibility after 15 years. And second, the 10-year term of probation has the opportunity or potential to extend Mr. Rambert's parole ineligible incarceration far beyond the 15 years,
Commonwealth
which
agrees
is
with you on the second point, right?
yes, I believe the Commonwealth has conceded that point. But I think the reality is that Mr. Rambert continues to have an unconstitutional sentence, and I think the point of contention between Mr. Rambert and the Commonwealth is the remedy for that problem. So
could you narrow to the remedy? So the Commonwealth says you can reimpose the life sentences remain in effect. You argue they could rejigger the entire process, but you can't just leave the life sentences in place, right?
correct, Your Honor. I think generally speaking, when it comes to resentencing, this court looks at an integrated sentencing package.
Wasn't this an integrated sentencing package?
It was, Your Honor. So there was a 30 to 40 year on the aggravated rape and 2 life sentences on the armed robbery and burglary. And then Mr. Rambert, a few days later, pled guilty on the remaining indictments and got a series of life sentences and term sentences. But I think for purposes of our argument today, we can kind of focus in on that, the sentence that was initially imposed, which was the 30 to 40 and the life, which I think when you read Perez says we look at the aggregate sentence. So I would say in Mr. Rambert's case, we've got an 18 to life as the aggregate sentence.
I'm confused what you think could be, if it was an integrated sentence and it has to be redone and the Commonwealth waived the Miller hearing, what could the judge do legally? I know what you say he didn't do, what he did was illegal, but what could he do legally at that point?
I think at this particular juncture, the only remedy that can be had is that Mr. Rambert's sentence be terminated entirely.
Why?
Because when Mr. Rambert went into sentencing in 2021, we can't disregard the amount of time that he's already spent in
I know,
prison.
but it seems like you're converting Perez 1 into an out of jail, after 15 years.
Well, I don't think that it's a get out of jail free card for a number of reasons.
Well, not free, but after 15 years.
Well, in reality, it's 40 years because Mr. Rambert had served 40 years. And we're also talking about an individual who was committed his offenses at 14 and 15 years old, which is an extraordinarily young age to commit this type of offense. Mr. Rambert had suffered from racial trauma, and was almost implicit at the sentencing hearing that there was probably some racial bias.
But just to clarify, then, under Perez 1, he would be I mean, I get that your client has served 40 years, is that right?
Correct.
But under Perez 1, it's not 15 years and then out, it's 15 years then parole eligible, right?
No.
No.
I disagree, Your Honor. I would say under Perez 1, what happens is we look at the sentence, and if that particular juvenile non-homicide defendant is not parole eligible at 15 years, it triggers resentencing. And in order for that sentence to be reinstated, then the Commonwealth needs to make its demonstration of extraordinary circumstances. The Commonwealth waived the Miller hearing, so what I would suggest to the court...
But couldn't the judge have just said, couldn't Judge Ullman have reimposed the life sentences with immediate eligibility for parole? They're saying that they automatically resurrect. I have some issues with that. But couldn't he have done, recreated life sentence, resentenced life, immediately eligible for parole?
Well, I have two ways to answer that. I would say the first way is factual and the second way is legal. So let me discuss the factual answer first. So when it got sent back from resentencing under Perez, Judge Ullman did a very robust resentencing hearing, which I think is part and parcel of what was expected under this court's decision in Perez too. He looked at kind of a broad, holistic approach, or took a broad, holistic approach to resentencing. And in doing so, Judge Ullman reached the conclusion that additional incarceration wasn't appropriate. I obviously argued that Mr. Rambert should be released, but the Commonwealth also believed that Mr. Rambert should be released on that particular sentence. And then the judge made his findings with respect to. So looking at kind of the mitigating circumstances and the amount of time that Mr. Rambert had already spent, the judge's findings were that further incarceration wouldn't serve any rehabilitative purpose and wouldn't protect the public.
Can I ask you, so you run into the whole issue that Judge Kaplan initially indicated in saying, well, this doesn't make any sense because he has already been parole eligible and has been denied parole, I think, 5 times. Are you saying that on a Perez remand, absent Miller findings, the defendant basically has to be discharged to the sentence?
No.
Okay, why not? I thought that's what I'm hearing from you, but tell me why I'm wrong.
Well, I was saying in this particular circumstances, I think that the judge could in a certain set of circumstances, a judge could re-sentence the juvenile defendant to something that was proportionate under Perez.
No, but you disproportionately, presumptively, is anything plus 15. So give me those circumstances.
I would say a set of circumstances where the juvenile non-murder defendant does not have the amount of time in that Mr. Rambert did and was not parole eligible at that particular point. I think that that's the difference between Mr. Rambert's case and some of the other cases that have come from before this court. And I think that's really kind of the point of confusion with the Superior Court judge. Mr. Perez, Mr. Lutzkoff, Mr. Washington, the appeals court case, those individuals were all serving term of year sentences. So at one point, their particular term was going to run out. Those individuals were going to be released from incarceration. So parole eligibility for them had, I would suggest, a greater significance. In Mr. Rambert's case, there is language, I would suggest, under Perez 1, that seems to suggest that a life sentence for a juvenile non-homicide offender would be disproportionate without the extraordinary circumstances after a Miller hearing. If the court will indulge me, at page 685, it says, juvenile defendants who do not kill, intend to kill, or foresee that life will be taken are categorically less deserving of the most serious forms of punishment than are murderers. So in Massachusetts, the most serious form of punishment a juvenile non-homicide offender can get is a life sentence with parole eligibility at 15. So if someone is resentenced and there is no finding of extraordinary circumstances, it seems to contradict the principle in Perez that we can't give the juvenile non-homicide offender this most serious form of punishment. I do want to point out, too,
Can't without a Miller hearing, but we can with a Miller hearing. But
with the Miller hearing and where there's been a finding of extraordinary circumstances, certainly the Commonwealth had the opportunity in this case, if it felt that a life sentence was appropriate for Mr. Rambert, they could have had a full-blown Miller hearing. I would suggest that, for lack of a better phrase, they're trying to eat their cake and have it too. They want the life sentence, they want the most serious form of punishment, but they didn't want to go through the steps of having a Miller hearing. Perez too says it's a difficult and complex task. We recognize that, but I don't think that the most serious form of punishment is appropriate here when the Commonwealth hasn't made its demonstration. And again,
At other times, we said if it's going to be more than a 15-year parole eligibility, you need a Miller hearing, right? It hasn't been complete consistency in the language. In other words, that a 15-year on a life felony other than murder would not require a Miller hearing. I know you just cited from Perez one thing it would, but at other times hasn't been that precise. Is that right?
that's correct. I mean, I'm not saying that it's a bright line rule. I'm just kind of making that analysis through, the dicta in Perez.
Yeah, okay, so I don't know that enough happened here, but if you're in the Superior Court and you're trying to, figure out this integrated sentence, clearly the intent at sentencing was to have this person who had committed these heinous crimes on parole for life. And if you don't have the life sentence, you lose what is a key element of the initial sentence. Now, maybe there needed to be a hearing and a decision about that, but that was part of the initial sentence, wasn't it?
You're talking about the sentencing back in 1983, Your Honor?
Yes, that someone would be on parole for life.
Right, but I would suggest that, and I know that's what the Commonwealth is suggesting, but that really undercuts Perez. I think the whole idea of Perez is to kind of go back to the drawing board and say, well, this judge in 1983 didn't have the benefit of the adolescent brain research that we know now. So we're going to reevaluate this sentence in light of this juvenile brain research.
That means, if I'm understanding your argument, what that means is that any time there's any resentencing of a juvenile transferred under the old statute, youthful offender, where the sentence took place before Miller and Dianchenko, you'd have to resentence. I think that's the implications of what you're saying. Maybe I'm wrong.
I would say if that 15 years of parole ineligibility is there, so Mr. Rambert was not parole eligible at 18 or until 18 years of incarceration. So I would suggest that that's the triggering event that sends the case back to the Superior Court for resentencing. I would also just suggest that the Commonwealth's proposal is a little problematic for a couple of reasons. It would also produce a wide range of results based upon the sentencing structure. So if, again, Perez says that it's the aggregate sentence, but if we parse out, life sentences and term sentences, then one set of individuals might have been sentenced in one way and would get this presumptively disproportionate sentence, but there might be another group of individuals, and just by happenstance of the way that their sentence was structured, would be eligible for resentencing under Perez. So I think that where Article 26 relies so heavily on proportionality that this kind of disparate results would violate Article 26. If there's no further questions, I'll rest on my brief.
Okay, thank you very much. Attorney Sherman.
Good morning, and may it please the court, Catherine Sherman on behalf of the Commonwealth. To begin with, the Commonwealth notes that it made an illegal sentencing recommendation below, as did the defendant. But ultimately, it was the judge whose resentencing led to this erroneous sentence that the defendant is now faced with. The judge exceeded the bounds of his authority in two ways. One, by going beyond the Rambert 2 remand when he revisited and resentenced on the life sentences, and two, when he resentenced on the term of year sentences but did not resentence in alignment with Perez. And as the court has been discussing, I would suggest that the lines of resentencing with Perez are quite clear. Perez, in its explicit language, says that the question before it is about aggregate sentencing for a non-murder juvenile when the parole ineligibility exceeds 15 years. It is not about the maximum aggregate time that a juvenile may be sentenced to. It is about the parole ineligible time, and that's consistent among the Perez cases, Lutzkoff, Okoro. It is about parole ineligibility. So the Commonwealth's, in our suggestion to the court about how we are asking you to help us remedy this situation, would be that the term of year sentences would need to be remanded for resentencing consistent with Perez. And noting that the original sentence in this case had complications related to truth in sentencing, for the purposes of simplifying and clarity, I would suggest that that would take the form of a term of year sentence at which the minimum was a 15-year parole eligibility. It could be less. It could not be more without a Miller hearing. But in this case, the resentencing judge could have simply resentenced 15 to 40 years on the 2 aggravated rapes, left all of the other sentences intact, and this juvenile sentence would have been in conformity with Perez.
I'm just trying to figure out what you argue in the brief and what you're arguing now are a little different, right? So you waive the Miller argument, so the judge doesn't conduct one. Mm-hmm. Then the judge imposes a sentence that's shorter than the one you recommend.
Yes.
Now in the brief, you're asking us to resurrect the life sentences, aren't you? Or am I misreading your brief?
I'm asking you to vacate and reinstate the life sentences because they never should have been resentenced
But
in
isn't
the first
that
place.
wrong, though? Because it was an integrated sentence, as Justice Lowy pointed out earlier. And when we have an integrated sentence, we consistently allow a resentencing of the whole package, don't we?
That's true, but I would suggest this is not an integrated sentencing scheme. Here, there were 2 term of year sentences. I'm speaking mainly to the large ones. There are other terms of years, but the 30 to 40 year sentences running concurrent with the life sentences. The life sentences were clearly the anchor sentences here. All other sentences ran concurrent with them. And in saying that this is not an integrated sentencing scheme, I'd point to this court's language in Lebeau. It's not a case I cited in my brief. It's 451 Mass 244 at 245. When describing an integrated sentencing scheme, this court notes that integrated sentencing schemes, their components work in combination, not isolation.
Okay, but let me, and again, I'm going to defer to my colleagues who sentence people regularly, while I did not. But the term sentences here precluded any parole eligibility for how long?
For
The
30
original
years.
ones. For
30 years.
so not only is the life sentence an anchor, but those sentences clearly appear to be an anchor in a case where this juvenile went on a heinous crime spree, right? Mm-hmm. So can we really suggest that only the lives are the anchor and that it's not an integrated combination sentence here?
I would suggest that that the life sentences were the sole anchor sentences because they, as the court noted, showed the judge's intent that this juvenile, whenever he be eligible for parole, the question of parole and the term of parole be dictated by the parole board and the circumstances at that time. At the time that this sentence was in place, under the life sentences, he would have been parole eligible at 15. He would have served additional time. However, once he was eligible for parole on the term of year sentences, it would have, though the decision of his release into the community would have
Don't they
rested with
work
the
in
parole board.
conjunction? Because the big sentences, the Judge Barton certainly knows what parole eligibility is. So the big sentences, term of years, work to parole eligibility. So he's not going to see the parole board till 30 years.
Yes,
Then, if he gets paroled, he has the life sentences over his head, right?
yes,
Which would continue on.
yes. And
So aren't
that
they-
I
aren't they-
suggest,
Right. Doesn't that suggest that they're all integrated?
no, because, and they're not integrated because every one of the sentences here could be isolated and revised without disrupting the entire sentence. And I think this case is a really good example of that. If the 30 to 40 year
No,
sentences.
I don't think so, because if you took just the life sentences in isolation, he could be paroled at year 20, correct?
And I apologize, I should have been more clear. The non-anchor life sentences, the non-anchor sentences could have been isolated and remedied without adjusting the proportions and purpose of the sentencing package.
I haven't
And
read Gilboa, so I don't know. We certainly have to do that, but I just don't, I think it's Justice Kafka's point as well. I'm not seeing how this isn't a complicated sentencing scheme that's integrated.
I would suggest that the cases that use that term of art, integrated sentencing scheme, most often, with rare exception, are cases where there are from and after sentences, where there's some sort of interdependence on when a sentence would begin or
But if we
end.
take broad pictures, doesn't Perez, because it's an Article 26 issue, ask us to look at juvenile sentencing and when does it exceed disproportionately harsh sentencing for parole eligibility? I mean, I get the technical parts with from and afters and parole eligibility that we usually do, but isn't this a little different because we're dealing with Article 26?
No, because the analysis of Article 26 and the disproportionality analyses in Perez and the Perez derivative cases are just about the disproportionality of serving more than 15 years of parole ineligible time. And here, though the defendant had fully served his term of year sentences at the time of his resentencing, his sentences would have conformed to Perez had the term of year sentences just had a minimum term of 15 years. His life sentences were and are legal life sentences, are legal sentences for a juvenile. He went through the robust transfer hearing. The life sentence, as he was sentenced at the time, was and is a legal sentence for a juvenile.
So the judge should have just left them alone.
Yes, they never should have been touched. And I think that's clear even in the language of the remand from Rambert 2, where it's referencing Washington. Washington is only discussing the term of year sentences and how that ought to conform to Perez, and also that even the decisions coming from this court in Lutzkoff and Okoro, not Okoro, apologies.
How do we deal with the practical problem, which is everybody agrees there's no point in incarceration for him, right? Am I misremembering?
The parole board does not agree with that.
Well, but Commonwealth and, the judge is in a box here. I'm not sure,
Oh,
no one's
I apologize.
defending what he did at this point, but the judge is in a box. The Commonwealth is prepared to end the incarceration, right? I'm trying to remember what the Commonwealth's argument was at this point.
Yes, I apologize.
Before the
The
judge.
Commonwealth's recommendation wasn't to end incarceration, because the Commonwealth's recommendation would have resulted in him,
You wanted the
Bill
3 to
serving
5. You wanted the
the
3
3
to
to
5.
5 on the from and after sentence.
Right, which you still wouldn't take the position could happen, because that would have inevitably occurred. He would have wrapped up a 3 to 5 from and after as well, with the 20 to 30, because they
With-
were truth in sentencing cases.
The 3 to 5, I apologize for not knowing the date of that. That was sentencing unrelated to the series of rapes for the escape.
I know that,
I
but
don't,
that's way back. It was way back, escaping DYS.
yes, it may have been, and I defer
would've wrapped.
to the court about, it may have. Though at the resentencing hearing in 2021, I believe the information from the probation and the parole department was that if the defendant was sentenced to a term of years less than, actually, I won't refer to the hearing because I don't have it completely memorized, but they did discuss the from and after sentence.
But I'm confused. So we have a problem, which is the sentence, the original sentence is now legal, and so is the subsequent sentence. The judge, what's the judge to do here? The judge, he's already served more time without parole eligibility than was legally permissible, right?
Yes.
So then, and the Commonwealth doesn't want a Miller hearing. So I'm just trying to figure out what the judge is supposed to do in these circumstances. And what are we supposed to do now? I understand what he's saying, but I don't understand yet what you're saying. We should, the judge, there should be a remand, in your view, to resentence, because, and you, originally in the brief was to reimpose the life sentences, but now I think you're moving away from that. Or-
No, that remains our position. We're asking for this court to,
And how do we address the fact that he spent this much time without parole eligibility? Is there any, the judge is supposed to do what with that?
at this, well, the defendant did serve more than 15 years of parole ineligible time, but had been parole eligible, as this court noted, for a significant amount of time before this 2021 resentencing.
So we leave that
He served
problem
18 years, I
unaddressed? I'm
believe.
just trying to figure out how we deal with that problem.
And by that, Your Honor, do you mean the overall time that he has served, or the?
He is, you say reimpose the life sentences.
Yes.
Which I take it was reimpose the life sentences with 15-year parole eligibility. He's already gone way beyond 15 years without parole eligibility. We just leave that as, sorry.
On his life sentences, so I'll begin with what we're asking in broad brush
Well,
strokes.
before you do that, he hasn't gone beyond the 15 years without parole eligibility. He's had 4 hearings.
That's
And
correct.
they've been denied.
And on those life sentences, he only had 15 years of parole ineligible time that he served, and then
Did he get a parole hearing within 15 years, or he got a
he
parole
had
hearing
his first
30?
parole hearing at, I believe, 18 years, but I'm not exactly sure. It was less than 20, certainly.
Okay.
With the term of year sentences, we'd ask that those be remanded for resentencing consistent with Perez. And that is either a term that begins at which the minimum end of the range is 15. It can be less. The high end of the range may be 40. It can be less because the judge has the opportunity to review his behavior since the that term of years was reinstated. But
How
for
do
the
we-
life
How do we deal
sentences,
with Perez 2? In Perez 2, we say there's no point in doing the Miller because there's no way the Commonwealth can prove that. Are we outside of that? I mean, you waived the Perez hearing the first time. How do we deal with Perez 2 and the idea that sometimes this is completely pointless because you're not going to be able to meet this? Are you suggesting you could meet this? I'm just trying to...
no. Well, my understanding of Perez too was not that it couldn't possibly be met, but the Commonwealth had failed to meet it and the defendant was resentenced improperly because he was resentenced solely on the nature of the crimes versus the consideration of his family life and his juvenile tendencies at the time. That was why that wasn't remanded, because it was improperly done. But I think Perez 2 is informative in terms of saying just that a juvenile convicted of non-homicide offenses be presumptively eligible for parole at 15 years. And that's what conformity with Perez would be, that taken to extend to other cases and the applicability of this in general, term of year sentences that are now unconstitutional for the juvenile offenders ought to be resentenced, could remain the same if there were a Miller hearing, but otherwise need to have a minimum term of year number of 15 years. That said, all other legal sentences that were imposed, including in this case the life sentences, need not be revisited because there is no constitutional violation when he was parole eligible at 15 years.
Did the Commonwealth take the position in 2021 that the original sentencing scheme was an integrated, comprehensive scheme?
Those words were not used and that wasn't implied.
Did it suggest any alternative to the life sentences?
Yes, both the Commonwealth
So
and...
it took the position that those life sentences could be revisited and should be revisited on resentencing.
That was the Commonwealth's position at the time, and that is not a position
Isn't it
that we abide
now
by.
waived that the Commonwealth, that those life sentences spring back to life?
Well, we're asking that they be reinstated because there was not legal authority to resentence on them. They never should have been resentenced. The resentencing that was done on at least two of the life
What is your
terms.
position as to waiver? I mean, the Commonwealth took a position, life sentence can be readdressed. Here's our proposal. It's illegal, but here's our proposal. And now you're asking us to say those spring back to life and you don't get a comprehensive integrated scheme. It seems to me that there might be an issue of waiver on the Commonwealth's position.
I do understand Your Honor's point, and unfortunately, looking at this record and the recommendations that were made by all parties, the sentence that was imposed by the judge, there are errors upon errors. And at this point, we're really calling upon the court's general supervisory powers to
Fix the
reinstate that.
Fix the mess that we help
Please.
make.
And also, in doing so, in reinstating the life sentence, give guidance for these future cases. There is, not to make light of how things went wrong. You know, I'm saying errors upon errors, but this is confusing. And I think at this time, when there was this resentencing, the judge was clearly trying to come to the right result and was referencing the case law and trying to understand where he stood, but he was confused.
But the stakes are, we haven't talked about how enormous the stakes are here.
Yes.
Because if the life sentences are reimposed, he's got new charges that could result in parole being denied. So this is not just an academic exercise.
It is not.
The stakes are huge here.
The stakes are huge here and complicated because right now the defendant has violated his probation on life felonies, is subject to...
Even you agree nothing can happen on
No,
that.
certainly not. No, he cannot be...
Revoked. He can't be revoked.
No, he can't. He can be litigated in the district court where those cases happened. However, here, it is a complicated situation and the stakes are so high. However, this defendant, through the fault of the parties and the court, was released back into the community on these life sentences when he shouldn't have been. There was no legal justification for it. He should not have been in the community to commit these new offenses because 5 weeks before this resentencing hearing, the parole board deemed him not ready for reintegration into society.
SJC-13269, LaForte Enterprises, Inc., v. Lantern 18 LLC, and others.